From one argument to say that the Freedom of Information request was too broad to seek out Harry's immigration files, to another argument that they were struggling to find the file, the alien file, the A file as it's known, to another argument that they weren't really sure that there was a full proper legal basis to request those files in the first place. The Heritage Foundation have surely had a difficult time getting hold of those files from the Department of Homeland Security. In this video, I'm going to take an even deeper look at that complaint itself, along, of course, with reference to the Freedom of Information request where necessary. It won't detail all of the exhibits because it'll be far too long, but nonetheless, you better sit comfortably because this might be a long one. Welcome back to the channel. If you didn't catch my previous video going into the details for the Freedom of Information request itself, that is linked in the description below. But in short, it's this document here. And a Freedom of Information request seeks out records held by public bodies which might be of public interest. And the public interest bit is an important factor in this case because that was one aspect that they sought a waiver of fees on the basis that it's public interest. But moreover, that the public interest aspect is why a lot of people will want to see that due diligence and fairness has been applied in this case, as in every case it should be. So in this video, as I said, I'm going to go into more detail about the complaint filed itself. The complaint details the request, the Freedom of Information request, but very specifically explains what happened, how they filed it, and why they relied on it, and what the response was. And it is a complaint in and of itself. From paragraph 52, plaintiffs submitted the FOIA, I'm just going to call that the request from now on, pursuant to the decentralized request system. It was sent to Department of Homeland Security headquarters and other places. And the request sought the following information. This is what I discussed in my previous video. In essence, all of the information relating to information for Harry's entry into the United States and his visa. So all of these records. Now, this will end up being part of a rebuttal to this request because on the face of it, it seems a broad request, although it is specifying what type of documents and under which forms. Nonetheless, it says any and all, which is very often a broad request, which we'll see in a few moments to be something that comes back as a bit of a rebuttal. Nonetheless, all records relating to requests for a waiver pursuant to immigration, national but not limited to email communications with the DHS office, and so on. So all of these different records here. Moving on, the US at paragraph 54. The request sought a fee waiver based on public interest, as I said, in understanding whether the department acted properly in admitting him to the United States, given repeated admissions of drug use and so on. Paragraph 55, the request sought expedited processing. So this should be done quickly. Paragraph 56, the application for expedited processing was supported by a 126-page Appendix A, which compiled news articles. I'll go into these in a different video, but news articles and national TV transcripts covering the issue of substance abuse, including own admissions regarding the use in his book Spare. Paragraph 57. CBP responded with what was clearly a form email. This just means like a template email, as in it hasn't been tailored, it hasn't been handcrafted specific to the request, just some form of a template. Email from CBP to Mike Howell. Your request was reviewed as a third-party request and did not include authorization that information of this individual business can be released to you. All third-party requests must include a signed form, etc., or if requesting records pertaining to a business. And so it concluded your request has been closed as insufficient. Please resubmit it. It goes on to complain here. The email not only contained obvious form language, default, template, not handcrafted, such as his or her, but also contained no mention of the application for expedited processing or a fee waiver, so ignored those bits. It also did not even consider the highly unusual nature of any privacy analysis of the request, given it involves a case which substantial media coverage surfaces the question. So this is not just a regular request. This is one which follows significant media coverage of fairly serious issues, of someone of significant prominence, and so on, of whether the department acted appropriately in adjudicating a high-profile case of entry into the United States by a celebrity figure who's affirmatively placed virtually every hitherto private aspect of his life in a public domain for commercial gain. The department regulations require such analysis, and this is under the rules. They must produce records covered by the Privacy Act to a third party if the Act requires disclosure of those records. And quoting here, where a request for records pertains to a third party, a requester may receive greater access by submitting a notarized authorization by a signed individual. The email contains zero analysis of the specific showing that is severely diminished privacy interest in the core factual privacy issues. So what's going on here is, ordinarily when you make a request, you have to provide a basis for that request and weigh it against aspects of privacy. So this is directly contradicting the huge publicity following these disclosures, and then pointing out the severely diminished privacy interest in the core factual privacy issue implicated by the request. The approaches of the department's actions concerning his entry and status in the United States, given the repeated public admissions of being a serial substance violator. Obviously, I'm avoiding certain words for YouTube flags here. Plaintiff, that's the Heritage Foundation, administratively appealed this denial, and then there's a letter attached. I'll go through some of these exhibits in a different video, but it does quote certain bits of it throughout here. Plaintiffs began their appeal by noting that the form email they were sent on the same day they transmitted the request violated a host of the department's own regulations concerning procedures required to deny or otherwise close a request, and quotes as follows: I'm appealing the adverse determination denying my request in full because CBP violated the regulations specifically, and names the regulations. There was a violation of 5.6 because no one signed off on the denial as required by statute. There was a violation because there was no name, no title, no position of the person responsible for the denial as required by statute. So ordinarily, somebody would put their name to this to say this is who is denied the request and why, but that was not the case. Violation of 5.6E2 because there were no descriptions of the exemptions applied in denying the request. So sometimes, as I've mentioned in previous videos, a department, a public body might have an exemption, a certain rule or regulation that would allow them to deny a request on a certain ground. But here, there were no exemptions applied, no descriptions of those exemptions applied in denying the request. Further violation because there was no estimate of the volume of the records withheld or a statement that it was protected by an applicable exemption as required. So they could have come back and said, yes, we have those, but there is a reason that we can't provide them. There's an exemption, here it is, but these are the number of documents, and that's as much information as you get. There was none of that. Plaintiffs continue to explain why the all but certain form response appeared to have simply not even considered the unusual facts to drive the merits of the request. I'm also appealing this request because I'm questioning the adequacy of the search as per the regulations. A third-party release is not necessary for this request because there's an overwhelming, countervailing public interest in the disclosure. So in other words, not one individual person should be third-party providing a release for the request. There's a significant interest, public interest, in this disclosure. Public confidence in the government would undoubtedly suffer if the departments failed to properly vet such a high-profile case. Quite right. Moreover, if Prince Harry was granted a preferential treatment, that would undermine public confidence in the department's application of equal justice under the law. By statute regulation, departments are required to respond to the appeal in 20 business days. So here we have several different time frames perpetuating from this original request. But plaintiffs heard nothing further. So USCIS meet and confer. So this was an interesting point here. On or about March 13th, counsel plaintiffs received a call indicating that they were having difficulty locating the file, indicating that they were contacting the plaintiffs in hope of conferring and gathering more information to process the request. I find that a bit odd. And frankly, I don't really buy that. The complaint goes on. No matter how an alien is authorized to enter the country, they will have an alien file in some form. The department makes commonly requested A files publicly available in electronic reading room, as I mentioned in my previous video. Counsel immediately engaged and explained that because of conventions applicable to the naming of senior members of the royal family, it's possible for the Duke of Sussex, Harry, Prince Harry, Henry, etc., could have been used as a number of different names on immigration forms. For example, given that his last name is Windsor, Wales, Sussex. So in other words, do a few more searches, try a few different names, and see if that helps you to find the files. They thanked counsel for plaintiffs for their assistance. Counsel for plaintiffs made clear that they should not hesitate to contact them if additional questions arose. If we can help you any further, please come back to us and we'll try and help you find your own files. Subsequently stated on the record that numerous press outlets that plaintiff greatly appreciated the cooperation and thought that the call was productive. Great, so very useful, but regrettably nothing further received. So you get a sense here that there's difficulties being thrown up and delays, but persistence from the foundation to even assist in finding the files, locating the files, but still regrettably received nothing further. Supplement their expedited processing applications. So departments were required by law to make a determination on the application for expediting process 10 days from business receipt. So if there's a request to get this done quickly, they have to make a determination by law on that application within 10 days. 10 days, even if the department attempts to allege some issue with internal routing of the request to invoke regulatory tolling or determination, expedited processing application would be due by the 3rd of April at the latest. On April 5th, these statutory regulated deadlines have come and gone. Plaintiffs transmitted a letter supplementing the claims for the expedited processing in hopes of prompting some form of action for the underlying application for expedited processing. And then there's another exhibit, Exhibit 13, which is the letter to the department. Again, I'll come back to some of these exhibits in other videos. Letter, Exhibit 14, and Exhibit 15, expedited supplementals. And then there's a description of what these are. 10 days, and even if the department attempts to allege some issues with internal routing, again, calculation of the date would be 30th of April. And so you can see the pattern here of time and delay. On April 13th, plaintiff was contacted by CBP, an appeals policy branch, secure messaging, etc. The message explained that unfortunately we experienced technical difficulties and now we cannot gain access to them. I apologize for the inconvenience. Because the appendices were transmitted by a static link, there was no apparent logical explanation other than delay. Plaintiffs did not receive this message until about April 19th. Plaintiffs replied with a static URL. 20 business days, 30 business days, 20 business days, etc. Again, delay. And then the correspondence assigned to the request tracking, the letter, the department's letter stated, after careful review of your request, we determined that your request is too broad in scope, didn't specify the identify the records, specifically identify the records which you are seeking, or only pose questions to the agency. Records must be described in reasonably sufficient detail. Well, you'll recall, without going back to, in fact, I can go simply back to the request itself. This was the request itself. fairly specific to me. Any of the records that pertain to any of these rules and forms to this individual. Nonetheless, it was denied for being too broad. And again, said nothing about the fee waiver and expedited applications. This statement is factually inaccurate, takes a frivolous position, and almost certainly was transmitted for the purpose of improper delay. Now, this is where it really sort of starts to heat up. As an initial matter, the department letter plainly never conducted a careful review of the request. Far from it. The department letter is clearly another form letter. And it goes on to explain why. Purporting to describe the content of the request, we determined that your request is too broad, did not specify specifically identify the records which you are seeking, or only pose questions to the agency. Moreover, form language includes plaintiffs failing to provide other things. The subject matter for the records immediately after the quoting language seeking specific records about specific forms related to the Duke of Sussex. The letter closed by requesting, please resubmit your request containing reasonable description of the records that you are seeking. Again, reasonable. So now that you're looking, this is what was requested here. This is the information requested. And yet the response was, please resubmit your request containing a reasonable description of the records that you are seeking. This is not a denial of your request. Upon receipt of a perfected request, you'll be advised as to the status of your request. If we do not hear from you within 30 days from the date of the letter, we'll assume that you're no longer interested in the request and it will be administratively closed. Neither the Act nor the regulations permit such a non-response response. Plaintiffs responded by email saying, this is a response to your April the 6th letter regarding this request. This correspondence is factually inaccurate, clearly a form document, and reflects no sort of requisite individualized consideration. Frivolous and almost certainly sent for improper delay. The request is clearly and legally sufficient. Please process it. Plaintiffs received no further correspondence regarding the request or appeal. So that was it. There was a response sent to this denial to say that they request a reasonable description of the records that they are seeking. And once again, this is a list of the records they were seeking. All records within the A file, the ALN file, including not limited to any and all applications for immigration benefits, whether or not adjudicated, any and all forms of these descriptions, automated targeting systems, etc., etc. Quite a comprehensive list. But nonetheless, no further response. And so that was it. There was no further response. So delay after delay, but no further response. And then we come to the first claim for relief, which I will probably cover in another video now. But that was essentially the background of the complaint based on the request, and resulting, I can only imagine, frustratingly. As lawyers, nothing is more frustrating than what we often refer to as a non-response response. They respond to you, but it's not really a response. It might be a denial, but it's not really a substantive denial. It doesn't really explain the denial. It's just a denial. And here, from saying, we're struggling to find the files, so then a conversation takes place. Let's help you find the files. It might be under a different name, because naming conventions, people refer to him as Harry. I don't think for a minute that they were only searching the records for the name Harry. But, maybe, I'm not being uncharitable here. But assistance was provided to try to locate those files. And there were further delays. And ultimately, plaintiffs received no further response regarding the request or the appeal. And then comes the first claim for relief. So that is the background. That is the complaint itself. Questions, thoughts in the comments, please. What do you think? Do you think that are these just delay tactics? Do you think that they genuinely couldn't find the files? Do you genuinely think, any other lawyers genuinely think that's too broad? I mean, I do. I see argument. I see some conviction in the argument that it is a broad request. But any request that begins any and all information typically is too broad. But it's any and all information for immigration benefits, whether or not adjudicated. So any applications that are made, whether they're granted or not, with respect to individuals named, and not forgetting that all of the reasoning behind it and the public interest and the potential unlawful contradictions here. These were the documents requested. So I can see argument that it's a broad request, but on balance, they are requesting these documents with a specific individual in mind. So I can't conclude that it is too broad, that it would be a flat out denial. And certainly with the delays and everything else, it seems a little bit odd. But anyway, it's resulted in this complaint, and the full claim for relief I'll go to in another video. But there we go. Thoughts in the comments box below, please. And do you think it's too broad? Do you think they're just going for delays? And do you think that the public have a right to see these files, to see exactly what happened and how this was decided? In the meantime, make sure you smash that like button and subscribe. I am almost coming up to 300,000. I am very grateful to you all for watching and for subscribing. And much more of this to come if that's what you want. Just as an aside, actually, while I do this, I will thank my channel members, my new channel members. And just as an aside, some people ask why I talk about this in the first place. Well, lots of people do want to hear this information, and it is in the public interest. So lots of people want to hear about it. Clearly, I often go by the number of views videos get, not just because I want views on the channel. Yes, of course I do. But at the same time, I go by the views because the more views a video gets, the more interest is shown. Therefore, I follow the audience. One of the best tips I was ever given for YouTube, Daryl Leaves, I will credit for it. He says, you just follow the audience. And if the audience watch, you produce what the audience wants. So I produce a range of videos, so please do subscribe. These are useful across the world, not just in the United Kingdom. Various legal principles are applicable all over the world. And I'm very grateful to you for watching, and I'll see you next time.